Hi, this is Kip from Alec Malik. In a prior video, I talked about a scheduled loss of a body part. And so a question you might have is, can I file scheduled loss for loss of vision? So the short answer is yes. I'm going to be talking about a Supreme Court case that occurred in 2023. And the case is called Cogan, Cogan versus the Industrial Commission. So Cogan versus the Industrial Commission. In the information below, I'll put the link to the case so you can download and read it yourself. But anyways, some facts about this. By the way, I'll talk about this on my takeaway of this thing. But this loss of vision kind of stuff, I don't know. This seems kind of strange to me. It seems a little bit. I'm not really sure what the logic is. It's just weird, and you'll see why. I think it's weird when I talk about it. But so this individual, this Cogan fellow, was filing a loss of use in one of his eye, in his right eye specifically. In this case, they talk about the Snellen fraction, which is perfect vision is 20/20, and I guess you get the Snellen fraction when you do. When you go to your optometrist and they have you look at the wall and they read the letters from the chart, and that from however you do on that chart will determine what your Snellen fraction is. So if you don't wear glasses or contacts, you don't know what I'm talking about. But anybody who wears glasses or contacts, they know about the chart thing. You take off your glasses and you read the lines of the letters, and you try to read the optometrist will ask you, hey, what's the smallest letters you can read, or which line can you read without it being blurry? And then they'll have you wear your glasses, do the same thing, and then they'll test your eyes doing the same thing. But in Ohio, 20 out of 200 or less with correction is consistent with legal blindness, apparently. So this particular guy, Cogan, before his work injury when he was a kid, he had a right eye injury. He had his natural lens removed in his right eye. He had a hard contact lens put in, which corrected his visual acuity to 20 out of 40. And then he wore eyeglasses. And in doing these things, he was able to maintain his commercial driver's license for a number of years. But without correction, all he could see, and I guess without correction, without his glasses, or if he's taken this hard contact lenses and his glasses, but maybe that's what they mean. But without his correction, he can only see like with 3 feet in front of him. So kind of like me, when I take off my glasses, it's kind of like an impressionistic vision of the world. Everything's blurry. I can't see anything. So his uncorrected vision was kind of pretty horrible. But 2009, this guy is not really lucky. And the weird thing is, whenever you read these Supreme Court cases, they're kind of these dry, sterile things that you read, but these are real people. So this Cogan guy, I mean, this is a real human being. This isn't a character in a story. This is this guy's life. And so in 2009, this injured worker, Cogan, had a right eye injury. So bad luck for Cogan with his eyes. Anyways, he ended up undergoing 3 procedurals through his workers' comp claim, a retinal detachment repair, and 2 corneal transplants. And then he filed for a scheduled loss of 100% of pre-injury vision in the right eye. And his uncorrected vision remained unmeasurable by the Snellen chart, i.e. he couldn't see in front of him. And his post-injury corrected visual acuity was 20 out of 400, which is significantly worse than the 20 out of 40 pre-injury corrected visual acuity, and then far beyond the being legally blind in Ohio, so 20 out of 200. So that's his post-injury corrected visual acuity, and obviously his uncorrected vision is, if it's corrected, if it's horrible when it's corrected, then obviously uncorrected, it's going to be equally horrible. And so that's kind of the crux of the issue with this particular decision, and you'll learn why now. So the DHO denied it, the SHO affirmed the denial, so they denied it as well. And then noting that 412357B, and again I'll put a link to that code section in the notes, and that's the code section which lists all the scheduled loss awards and how many weeks you get for X body part. So, and they say 412357B requires a comparison between an injured worker's pre-injury uncorrected vision and post-injury uncorrected vision. So that's kind of the issue that, and then the 10th district found that and this is the injured worker appealed to the 10th district, and they found that the commission predetermined that Cogan's pre-injury uncorrected vision was the appropriate baseline without accounting for the circumstances unique to that case. So the question is, for the pre-injury, what are you using as a baseline to compare the two things? Because you got to, for loss of vision, you got to compare the pre-injury, your pre-injury vision acuity, and then you have to compare the post-injury vision acuity in order to give a loss of vision award. And they go into discussion. The Supreme Court, and then the commission appealed the 10th district's decision. So the commission appealed, and then so the Supreme Court is addressing the 10th district's appeal. And then the standard for assessing post-injury vision is, again, the claimant's post-injury uncorrected vision. So that doesn't change. So when you're applying for loss of vision award, it's the post-injury uncorrected vision is what you're comparing to whatever the baseline you're using for the pre-injury. So, and we'll get into that. And they go again, the standard is, again, post-injury vision is the claimant's uncorrected vision. And this is where it doesn't make sense. I don't know how this works and for practical purposes. Surgical procedures and optical prosthesis may not be considered when determining a claimant's post-injury vision. So I could see, I could take off my glasses and it's like, okay, this is my uncorrected vision. Okay, sure. And you could take off glasses. I don't understand, how do you assess? I mean, you can't take off surgery. You can't be like, okay, well, we did the surgery, we'll unsurgery the person. I don't understand how that works, nevertheless. But the court mentions that, so 412357 does not address the standard for assessing pre-injury vision. And they give an example. So maybe another video I'll talk about this case. There's this case, Lazy Boy versus something. So it's another Supreme Court case, and then the citation is Lazy Boy. So somebody got injured at Lazy Boy. The claimant had a pre-injury accident to his eye. His vision at that time was 20 out of 200. He had a transplant, then his vision was 20 out of 50. So kind of similar to our guy. And then he had a work injury and his vision reverted back to 20 out of 200. In that case, the Supreme Court said it was okay that the commission used the 20 out of 40 baseline versus the 20 out of 200 baseline. Had they used 20 out of 200, there would have been no vision loss. So I'm assuming it's supposed to say 20 out of 50 baseline. So it looks like in that case, the Lazy Boy, they used, and so they could have used two first pre-injury baseline. The point is, Lazy Boy, they could have used two different things. So they could have either used his pre-injury, his vision prior to the work injury, which was 20 out of 200 uncorrected, and then he had a transplant, and this is before the work injury, and he had a transplant, and it was, I don't know, it was either 20 out of 40 or 20 out of 50, but nevertheless he had a transplant and his vision was improved. And they could have either used the 20, that transplanted corrected vision as the baseline, the pre-injury baseline, or they could have used the uncorrected, which was terrible, this 20 out of 200 as the baseline. And the significance would have been, had they used the 20 out of 200, its post-injury uncorrected vision was 20 out of 200. If they would have used the pre-injury 20 out of 200, there's no vision loss. So this guy did lose vision loss because it was corrected, but but if they used, depending on which baseline they used, it would have impacted whether he got a loss of vision award or whether he did not. So, so the Supreme Court in this case, this case that we're talking about, this Cogan case, and they say, and this they kind of address that, depending on the circumstances of the case, a claimant's pre-injury visual baseline may not always be his or her pre-injury uncorrected vision. Okay, so their pre-injury visual baseline, their how good their eyesight is, may not always be his or her pre-injury uncorrected vision. So I guess they're saying you don't have to use the uncorrected pre-injury vision. It could be corrected, and that's okay. But that's up to the Industrial Commission to determine. So what the Supreme Court did in this case is they said, okay, we're going to bounce it back to the Industrial Commission. And that's what could happen with these things. And the Industrial Commission will have to determine the claimant's pre-injury visual baseline. And then they'll use that baseline to determine whether or not the medical evidence supports a loss use award for total loss of sight under 412357B. So whether or not the medical evidence supports an award for total loss of sight under that statute. So, and if we go back to the facts in the beginning with this fellow, this Cogan guy, remember he had this injury as a kid, and then he had surgery to his eye, and he had these hard contact lenses which increased his visual acuity to 20 out of 40. So, and then I guess he wore eyeglasses, but these hard contact lenses was 20 out of 40. But after his 2009 work injury, his uncorrected, well, I guess they're saying his corrected visual acuity was 20 out of 400. So his uncorrected vision was atrocious. So his uncorrected vision was this Monet vision. And so if his uncorrected vision was Monet vision, and they used his pre-injury corrected visual acuity, that 20 out of 40 as a baseline, then he might get a loss use award. But if they used his uncorrected vision, then he gets no award, because pre-injury vision's terrible. He has Monet vision. Post-injury, uncorrected, his vision is terrible. He has Monet vision. So Monet versus Monet means no loss of use. But if it's post-injury Monet versus corrected vision 20 out of 40, then there's a loss of use. So pre-injury 20 out of 40, post-injury Monet vision, there's a loss of use. So that's what they're saying. That has to bounce back to the Industrial Commission. Will have to determine whether, the baseline, and that'll determine whether he gets an award. So the reason why I think this whole case is strange is, I mean, maybe there's some fairness to the way they do it, but I think it's weird that they're using uncorrected vision as the post-injury baseline as well, because it's just weird, because it's like you get injured, you injure your eye, and then you get your surgeries, and then you wear your glasses, and then I guess my thing that's weird is with the loss of use of, like, the hand, for instance, the standard is for all practical purposes you've lost the function of the hand. So you're examined for your hand, and if you can grasp, if all you can do is grasp like a Coke can or hold like a pen or pencil, but you can't really do anything else with your hand, then you may be granted a loss of use award for that hand, and that goes to the functionality of the hand. You cannot use it, and my thing is it's they're not really looking at the functionality of the eye. It seems like it's like a different standard that they're using, and it seems weird. It's almost like, can you see? Can you function like a normal, human being? Can you walk around and can you see? And if you can't walk around and see and interact with the world with the eye, then for all practical intents and purposes, you've lost the use of vision in your eye. whether you're wearing glasses or not. But they're going with uncorrected vision, post-injury uncorrected vision. So if before you didn't wear glasses and now you have to wear glasses, you got to take off your glasses. And maybe that's fair because, you know, with the glasses, maybe you could still function. Without the glasses, you cannot. But it's kind of a weird. It's a weird. I don't know if you could see it, but again, the hand and things are looking at the function. They're looking at like how much vision you do or do not have, rather than what can you see or not see when you put on your glasses. So I find that it's just kind of it's a weird thing, and and this whole it doesn't really totally make sense for me. And sometimes you'll get these Supreme Court decisions and these rules that don't really make sense, and I almost wonder if the person who came up with that rule, if they don't wear glasses. But because they're getting into these weird analysis of pre and post injury vision as well, and it's kind of like, who cares? In my opinion, it's like, who cares? Unless the person before the injury was, you know, like Stevie Wonder or Ray Charles, and didn't use their eyes to work or interact with the world. It just seems strange to get into that whole discussion or analysis. And then the other question is, again, how do they measure post-injury uncorrected vision if you had eye surgery like the guy in this case? How does that work? I can understand glasses you can take off. Okay, glasses, it's uncorrected. But you can't take surgery off, and it just, I don't know. I don't like this case, and I don't particularly like the standard. And sometimes when you don't like a case or you don't like a standard, then that kind of is kind of like the sniff test. It's not really the best way to approach this, or the courts and or the legislature hasn't approached it in the most coherent way, or the best way that they could have. That's my opinion. And even the court kind of goes in this discussion where it's kind of like, hey, this lazy boy decision was going to create additional problems, and here we have an issue where the additional problem has arisen. Anyways, so the big takeaway is, if you have an eye injury and you can, if you've lost the eyeball, then that's easy. I mean, it sucks for the person that's lost their eyeball, but if you lost your eyeball, then you've lost that body part. But otherwise, if it's been injured, then this is the analysis that they're going to go through. Again, they're going to compare some baseline of the pre-injury vision, either corrected or uncorrected, and then they're going to go compare that to your post-injury uncorrected vision, and if there's a difference, and the difference meaning it's gotten worse, I guess significantly worse, then they're going to determine if you have a loss of sight award or not. Loss of sight under 412357B, and if so, then you'll get paid. If not, then obviously you won't. So that's the outcome with this case. It's kind of a weird case, but that's that case. So we've gone, in this video series, we've gone loss use of a hand when you actually still have the hand and how that works, and loss of vision of an eye when you still actually physically have the eye. You can pursue these things, but you'll see kind of the hoops that you have to jump through. Nevertheless, workers' comp is, as I say at the end of all these videos, it's a fairly complicated thing in Ohio, so don't do this stuff alone. Ask your family, friends, neighbor, medical provider, co-workers, hey, do you guys recommend a workers' comp attorney? Give me that person's number. Call that person, look up Google, but run your work injury by an attorney or a bunch of attorneys, and they'll tell you if you need an attorney or not. Otherwise, and then pick the one that you like best. But get somebody involved, because this workers' comp stuff is super complicated. It's not a good idea to do this on your own. So you've been listening to Kip from Alec and Malik. I appreciate you listening. Stay safe, and we'll be back next time. Thanks.